here, Your Lordships, is that originally, when the vacancies are notified, the rules, the Chhattisgarh rules, do not require enrollment at the time of the vacancies being notified. Subsequent to that, there is an amendment to the rules. In the amendment, they introduce this condition of being enrolled. After this is the advertisement. Now, there is a first line of challenge. So there's an original.
In the advertisement, what is provided?
Yes. So the clause in the advertisement is at page 29. It's as per this. But subsequently, what I'm saying is that the rule has also been amended by the government, because in the first round of litigation, when this was challenged, the High Court prodded the government and said, please rediscover, go back on this. There was a direction, and then they amended the rule. Now, the difficulty is the amendment is in our favor. The amendment now does away with the requirement of enrollment, but they are applying it to our advertisement. Exam is on Sunday, Your Lordships, 21st. So
how many petitioners are there?
We are about 20 in
all the three categories.
I mean, the next matter is same.
You enrolled, and then when you went for this APP job, you got suspended your enrollment.
Yes, Your Lordships.
They're all enrolled.
So, and you are for whom?
My Lord, I am for the petitioners in the next matter, in item 38. Your Lordships may just, my Lord, when Your Lordships rendered the
prosecutors.
Pardon me?
All prosecutors.
No, we are not.
No, that's what. That is a difference.
We are government servants, my Lord, Panchayat Secretary.
Were you also enrolled initially?
Pardon me?
Were you enrolled initially?
No, we were not enrolled initially. We were not enrolled. But what I want to point out, my Lord, if Your Lordship has para 90 of Your Lordship's judgment, my Lord, in All India Judges Association, Your Lordship consciously said that needless to state that all such recruitment processes which have been kept in abeyance in view of the pendency of the present proceedings.
Yes, we have made it applicable prospectively.
Exactly.
But then whether the government servants who are working in Panchayat Raj department, can we apply?
We satisfy the condition, my Lord. We are law graduates. We are graduates, my Lord. That's not the problem. But, my Lord, because...
No, we can understand the public prosecutors and the prosecutors of the CBI.
Government counsel, because they have to, in terms of Rule 49.
Not exactly judicial or legal function, but...
we also said in that judgment that you should have 3 years experience as an prospective.
And the case is only, my Lord, that is prospective. Your Lordships consciously made it prospective by saying that in respect of advertisements already issued, the rule position as it existed will apply.
They are out.
That is our limited case.
The students may be entitled to who are not completed, the law graduates who are not completed 3 years. If the earlier rules permit them, they might have a case. But if you are already working in the...
Lordships, with great respect, this matter doesn't really deal with the aspect of experience. The only issue here is because there is no requirement of experience.
There is one petition by the students also, I think.
Yes,
who do not have the experience of 3 years.
Yes, so the petitioners in my case are mixed. Some are government counsel, some are students, some are prosecutors. So the issue here is not with respect to...
Attaches, my Lord, either because you're a student or you're serving in some employment, so you can't
restrict the prosecutors.
But who are law graduates? So everybody is...
No, my learned rule is on different. If the candidates who are lawyers, enrolled as lawyers, and thereafter after their selection as a public prosecutor or the government counsel,
yes,
have suspended their sanad, then they would stand on a different footing. But the candidates who have never enrolled and directly taken employment somewhere else.
But if they always wanted to, for instance, be a prosecutor, then because of Rule 49, they may have chosen not to.
Something in your favor.
Very well. No, if I can just suggest, since the exam is on Sunday, day after, because the notification only came on the 9th, if it's possible to permit us to attend and sit for the exam and then subject to the outcome of these proceedings.
This will require consideration, my lord, because you're.
But no, but insofar as your candidates are concerned, you were never enrolled. It's a, yeah, they are on a different pedestal that once enrolled and after enrollment, upon their selection as a public prosecutor.
The reason for that is that after I got my law degree, before even I could enroll, my lord, I got this job. So I took up the job.
Informed choice. Informed choice.
And subsequently, Your Lordship, this
Eligibility, my lord, the eligibility condition, as it was applicable on the last date of filing the form, did not require. The rule had been amended, as my friend also pointed out. My lord, may I just tell Your Lordship a couple of things, my lord?
No, what she
Notification.
said was, the rule is now amended. But then
Yes.
the rule was amended to bring in this enrollment, but before the notification, advertisement came.
no. So there are actually three different legal regimes.
No, what is this rule requiring enrolled as an advocate under the Advocates Act? What is the date on which these rules are notified?
So I'll tell you, Your Lordships, initially, prior to the vacancies, which were notified on 19th of January 2024, the rules did not require enrollment. Then there's an amendment of 5th of July 24, which is the impugned amendment, which
5th of July?
requires enrollment.
July 25 is the amendment.
24.
Yes,
24.
July 24.
2024. The advertisement is 23rd of December 2024. Now, because this is challenged on this very ground,
What is the date of advertisement? 3rd of December.
23rd December 2024. Now, because this advertisement is challenged on this very ground, the state is directed to amend the rules. That's very important. There's an interim order by the High Court, not challenged by the state.
Where is that interim order?
Yes. Worships, that is at page 58, and please see page 61 and 62 of the SLP.
62.
61. Yes, it starts at page 58. Please see page 61. Last 4 lines. Precious has page 61. A candidate who is a law graduate, so bottom of page 61. A candidate who is a law graduate, whether or not is enrolled as an advocate, would hardly make any difference, as he or she will also have to go through the same scrutiny which the other candidate who is enrolled as an advocate has to go. Hence, prima facie, we are of the view that for the present, the petitioner shall be permitted to fill up her online form, and in case she fulfills all the other criteria, she may be permitted to participate in the recruitment process. Since the last date for submission of forms is so-and-so, we direct the Public Service Commission to extend the last date of submission. Further, purely as an interim measure, the respondent Chhattisgarh Public Service Commission shall permit the candidates to fill their online forms even if they are not enrolled. Corrigendum, then they make it in rem, and the last 2 lines at page 62 are very important. Further, we request the respondent High Court of Chhattisgarh to revisit the amendment brought in wide annexure P1. This is the original impugned amendment in light of the judgments of the Apex Court as aforesaid. Now, pursuant to this, the matter is adjourned on various occasions. The court is assured that there is an amendment in process, and thereafter the amendment is passed at page 67. So this amendment is because of the order in this very case on this very issue. 67 is the amendment.
Yes, yes. If you notice, 4 weeks, just the permitted by identity order. We direct that the Chhattisgarh Public Service Commission shall permit such of the petitioners who are possessing the requisite qualification, except the one provided under clause 4B, that is, you enrolled as an advocate under the Advocates Act 1961, bracket number 25, 1961. Paragraph. However, we clarify that the appearance of the petitioner in the examination would not create any equities.
I'm so grateful. Lordships, only thing is the clause is three, subclause 4, subclause B.
So it is 4, clause 3.
Clause 3, Lordships, at the middle of the page 43, it starts with 3.
But
It is 3, subclause
3, clause 3, फिर Roman 4, फिर उसके बाद में B.
I'm extremely clear.
Malaj, I'm so sorry. Item 39 also, Malaj, same order.
Yes, same.
I'm so grateful.
Yeah, but it is also made clear that since the advertisement process has commenced prior to our judgment dated
20th of May.
20th June,
20th of May.
20th of May, 2025, the commission shall also not insist on the requirement of 3 years experience of the candidates at the bar. He is actually at the bar.
Grateful, Lordships.
Grateful. But the order could be candy.
Yes,
Yes, how good.
grateful.
Madam?
Lordship, in item 6, I'm requesting for a short passover being led by Mr. Patwalia. He's on his legs. Requesting for a short passover